Mr. Pack?
Good afternoon. My name is Jeff Pack. I'm an acoustical consultant. The acoustical fence is exactly what that is a fence. We're not recommending a sound wall per se. This can be a wooden fence that could, if needed to, extend across the diocese property to shield that triangular area. That's fine, and it could be constructed in sort of a temporary fashion, so if and when that section of the diocese property becomes a right-of-way, that can be demounted, and you're still protecting the properties to the north with the remainder of the fence. The City of San Jose zoning ordinance does not apply to moving traffic in a right-of-way. So when the cars come onto the property where the zoning ordinance would come into effect to the cars that are on the property, they're behind the acoustical fence, therefore that triangular section is shielded.
Okay.
If you have any other questions, I'd be more than happy to entertain them.
Questions of Mr. Pack? No questions. Thank you.
Thank you.
Thank you. Gloria Ballard with MH Engineering again. I would like to, and I know I'm repeating this, the mobile home, my understanding, the judge allowed it to stay so they could store the structures in it. The reference was made 3, 4, 5 times that the applicant has not yet removed and therefore will not obey the law because they are not removing the mobile home. My understanding is the county has not required that mobile home to be removed until today. It was made a condition of the use permit that it has to be removed within 60 days. I'm repeating myself, I know, but I wanted to put emphasis on that. The pictures that were shown by the neighbors still obviously unhappy with the few people that visit the site. If you saw the assembly that they spoke to in those photos, there was one with one woman in it and one with one woman and one man. I'm not excusing that people may have walked onto the site to pray, but I ask that you look at what those pictures showed. And if that is a serious, severe violation, I hope this commission doesn't hold the applicant accountable. They've been told not to come onto the site. The neighbors referred to the flimsy orange fencing tape, fencing. In the meeting we had with Mr. Gerard as to how we could keep people from trespassing onto the property, the fencing, and it was specifically that orange type of fencing that was discussed as what was to be used. I just want to take away from the commission, unless you're having the thought that the applicant wasn't serious about what they were being asked to do. What was done was specifically what was discussed. You saw the picture with the auto on the towing truck. That happened the day Mr. Pack, the noise consultant, was there to do the noise study. On the street on Klein Avenue, there was an accident with a woman, and the tow truck picked up the vehicle and pulled onto this property. And if that tow truck blocked the neighbor's property, it's out of control of this applicant. There was an accident that happened on the property. We were aware because Mr. Pack told us that he witnessed the accident. We hopefully we've addressed Mr. Abel's questions regarding the right-of-way. I hope that you can look to the Health Department to address any questions regarding the contamination questions that the neighbors raised regarding the proposed leach field. We were asked specifically by Mr. Gerard in this application to obtain a will serve letter from San Jose Water Company. We are in their sphere of influence. And lastly, before we proceeded with this complete application, we did see if the property could be annexed to the city of San Jose, and it does not fit that criteria, so it will stay in the county. So hopefully, I took good notes, and I addressed what the applicant could address, with the exception of what has to go to the health department. I hope my presentation has been complete. Are there any questions, or
Any questions?
did I miss?
No questions. Thank you.
Thank you.
Are there any other speakers that wish to? Seeing none, I will close the public hearing, input portion of the public hearing at this time. Commissioners? Questions, discussion?
You know, I want to thank to all the neighbors that came over here today and speak, against this project. What I saw again when I read every one of your letters is a lot of energy, but also we have to look at the other side. We just cannot look at your comments and, it's a great work. Whoever was organizing you guys, it's a great work. I respect that organizing effort. But also there is things that I notice, myself, and, all you guys that came in here today, it's great to organize in good, other good causes. This one is, and I'm going to tell you right straight to you, every one of you, put yourself in your shoes. All those of you that have property there, if you were to make a room, make something to improve your property, and we'll have this opposition, how you will feel on this. I also, kind of my little antennas went up seeing the property of the diocese. It's a conflict of interest here. Somebody's pushing you guys behind because they are ready to develop also the property. So what is the play here? Now, I recognize Kim. She's a great planner. I know, but I have a question for you. How you feel in your recommendation of this? And I know how you are very professional. I just respect your opinion.
Yeah, with the public hearings closed. So
Okay, public hearing is closed. That's
that
okay.
was a
But
rhetorical question.
okay, go back. I didn't make that question before, and to me, even right now, with all your comments, it's a balance. But I'm ready to make a decision. I don't know what I'm going to say on my decision, but to me, and like I said before, instead of a confrontation, something that we have to come to the ground and short those differences. And also, what is proposed, and I have read this, and I have read that the county, they are putting everything they were asked to put. So, I don't know, I'm still undecided. I let other of the commissioners speak on this issue.
Thank you. Other comments, please? Commissioner Cobble.
Thank you, Mr. Chair. I have a couple of questions, and let me start by saying I think this is a difficult decision. I have been attending Planning Commission, City Council, and Board of Supervisor hearings on land use matters for 30 years, sometimes as staff, sometimes representing applicants, now sitting up here. And I have heard public testimony against religious institutions that offended me, and where it felt to me like the neighbors opposed it because of who, you people coming into our neighborhood and that kind of thing. And I will say that I didn't hear that from this neighborhood, which I appreciate. I think the neighbors tried to stick to the facts, and it seems to me that the root of the problems or the root of the concerns is based on a history of noncompliance and a fear that that will continue. And so to me, as I look at this, a use permit is only as good as its conditions and the permit holder's compliance with the conditions. And that's my focus. If we approve this, are the conditions correct? Are they strong? Are they clearly worded? So that the applicant can't claim, I didn't understand that I couldn't do this. So one question I had is someone raised the concern that there won't be the 100 fixed seats. People could pile in a whole bunch of chairs. When I read the plans, it says on the plans 100 fixed seats. So to me, that tells me if you don't install 100 fixed seats, you have not complied with the architectural and site approval. Is that right, Kim? Because it's not just illustrative. For the purpose
Correct.
of the document that you would attach to the approval, it says 100 fixed seats.
100 fixed seats. They are
Okay.
required.
Just to add, Commissioner Cobble, sorry to interrupt, but also if you look at the architectural and site approval conditions of approval, number 1, it lists 100 fixed seats, so that is a condition of approval also.
Okay, that's good.
Sorry to interrupt, but it would look like there's plenty of room if they wanted to add some movable seats in the space, some folding chairs. Could be, there's plenty of space for folding
Yeah,
chairs.
which brings up fire code issue. In other words, you have 100 fixed seats. What does this building allow as far as fire code? Or do you want to say 100 people, that's it?
Well,
At this
It does
point, I
say
don't
100
think
people.
we know separately, when the building's built, the building office and the fire marshal will look at it and do an occupancy rating, and oftentimes at this stage of the game, we don't know that. That being said, I will say this, both in terms of the conditions, over and over a couple times, the maximum intensity of use on the property is 100, and that's in the conditions. There are various times, and it's also going to be required, the conditions are recorded on the property. So if this property owner, subsequent property owners buy the property, very clear that the maximum intensity, maximum number of people is 100 people.
Thank you. A question, proposed condition 6 for the use permit talks about approved hours of operation. And I think hours of operation can be a difficult term to understand depending on the nature of a use. Obviously, the priest and family will be living on site, so that's a 24/7 use. What does hours of operation mean? If there's 3 people inside the assembly hall at 8:30 finishing their prayers, would you consider that perhaps minor, but would that be a violation of this condition?
Well,
Other
Yeah,
than the priest
yeah.
who lives there?
Sure. The hours of operation are the hours of operation, and
No, what,
if
but
there's,
what is
if there's evidence of assembly beyond these hours, which are in the use permit, technically that would be in violation. We'd just have to look at the size, intensity, and the nature of that, but it's very clearly spelled out. But for assembly on this site, it's limited to 10 a.m. to 8 p.m.
Okay. Another question, do we know that this property owner has the right to use the shared driveway for this use, or is that something that we as the county leave between neighboring property owners? If they have a dispute about the use of an easement, they work it out and it's not our problem, which is fine.
Yes, land development engineering did review the application, verified that there is legal access for both properties.
I know there's legal access, but that it can be used for this purpose, not,
Yes.
okay, okay. Okay, I think those are all my questions at this time. I'd just be interested in other questions, and I think the concern I have is that for particularly, I would say, schools and churches, if they are good and successful, they grow. And there was an example a couple years ago of a very fancy schmancy private school in Palo Alto that, lo and behold, had grown like 300 students over their use permit. And suddenly people cop to, wait a minute, what's going on? So I'm concerned. I think this is actually, it's very restrictive if the property were in the city. This is a relatively small building for a religious institution, relatively small number of people allowed, happens to be in the rural county, so it's a different set of rules. But if you're looking around at urban religious institutions, this is pretty small potatoes. And so I think there's going to be a pressure if it's successful to want to grow. And unfortunately, we have a history of not complying with the rules. And so I'm still troubled by that. I do think, I'm not an architect, but I think the building plans, the external building is actually beautiful. I think the landscape plan is beautiful. So in terms of a physical improvement to the site, I think if built according to plans, this is going to be a real asset to the neighborhood. Will they comply with the conditions? I'm still struggling with.
Thank you. Commissioner.
I, too, just want to thank everyone that made the effort to just make comments, and you really helped to frame a lot of the issues, and I just, again, really appreciate that involvement. I have a couple of kind of technical questions I'd like to ask of staff myself, and that is, I did see at kind of the introduction, they talked about the daily amount you can have 5 at a time and 15 maximum. Did I read that right? And if so, how is that for individual prayer, 5 attendees at one time, total attendees per day, 15. And I don't know if that's carried out in the conditions of approval. And I'm not sure the thought, but if that is the case, the thought of why 5, why not just say 15 are allowed in a day? Why is that limited to 5? And then another question would be if you could just let me know what condition number 14 is. I'd appreciate that one.
So as far as the number of attendees, those are the numbers that were proposed by the applicant as far as their estimate of the intensity of the services. There are 100 fixed seats that are proposed. It's very difficult to regulate 15 people on certain days and 50 people on other days. So that was for illustrative purposes. Those are not in the conditions of approval. The conditions of approval state that no more than 100 attendees at any one time.
Okay. And I feel much more comfortable with that rather than having to sit there and try and monitor that. For me, I agree with a lot of the comments my fellow commissioners made. At this point, I don't know that I have trust in the applicant, but I need to have trust in the enforcement mechanism of the planning department. And that's where, at this point, I do like a lot of the things that were put in there to monitor this. I like the whole noise thing. To me is kind of theoretical, and I'm very happy that there's a couple of times where they will come out and actually do actual measurements during activities. So I think that is very important for this. And I like the fact that there's a nice big sign that defines exactly what the uses are, and so there's no question. A lot of times with nonprofit institutions, there is turnover of people over time, and we want to make sure that as this runs with the land that everybody knows, and they can't just say, well, I wasn't there for that thing, so I didn't know. So I do appreciate those factors in this, and I think the staff did a really good job of really trying to say what, that if we're going to allow this use to go on the property, that we want to make sure that there is an enforcement mechanism in place to make sure that it is happening. And so because of that, I would be willing to support the staff's recommendation.
Thank you. Commissioner Schmidt?
Okay, well, my comments are very similar to just about everyone else's comments too. That thank you to the neighbors for putting a lot of effort into the presentation and being very clear and doing lots and lots of research. This is a difficult situation, and it's very hard with this history of noncompliance. The applicant has talked about being a good neighbor. I don't think they have been a good neighbor. If we approve this, they will need to be a good neighbor and need to, I think, mend fences. Well, yeah, acoustical fence, build fences, mend fences with the neighborhood. And as has been mentioned, there has to be very clear and good enforcement of this. I'm quite sure, and if this is approved, that the neighbors will watch very closely what is going on. I have my concerns in that I think the property will allow more than what is being described here, and will allow for additional people to live there, will allow for additional people to assemble there. But if there is good enforcement, then it could work. I was going to ask another water question, a detailed water question. The neighbors have also mentioned not only the septic capacity, but just any contamination of water, groundwater, and could you address the potential contamination?
Yes. So basically, with respect to the septic system and groundwater, it was based, the separation, or the vertical separation between groundwater and in the bottom of the leach field is determined by the percolation test. So with that being said, we have at least minimally 8 feet of separation between the bottom of the trench, leach field trench, and to where we tested. So what we did was we dug a pit 15 feet deep. As we went through, we kind of monitored and observed if there was any high groundwater. Well, while we did that pit, we didn't observe any groundwater at that time. We terminated our pit at 15 feet deep.
Speaking of groundwater, I would imagine it's kind of low right now because of the drought conditions we've had for a long time. Would you think that could change in the future and have any impacts?
Well, when we did our soil or pit, we didn't see signs of high groundwater through soil modeling or anything of that sort that would have led to us to believe that there was high groundwater associated with that.
They're saying that there's not a history in the soil that shows that there would have been.
Visually, we would not have been able to tell you that through when we were doing our observations.
So I'm sorry, so you would not have been able to tell that?
No, not at that moment.
Okay. Well, I think, as I had mentioned earlier, I think if we approve this with the condition about water quality, should say that if they have the large events there, that they should be required to have chemical toilets, not just be allowed. Anyway, I think this is complicated, and again, if this is approved, it requires that the Kantai Temple be a good neighbor, become a good neighbor.
Commissioner Schmidt, sorry to butt in, but one consideration Darren and I talked earlier, it would be on the porta potties, modification to condition 44. For these special events, chemical toilets shall be used to augment the restroom facility. So just you could consider a change to that condition of approval.
Thank you. That's exactly what I would want to see. Thank you. And I was done speaking.
Commissioner Resendez?
Yes, I'm going to make a comment about code enforcement. You know, myself as an immigrant, I came over here when I was 20, and it's hard to understand all those issues, especially code enforcement. Now, I'm 100% fan of code enforcement. I like it. What I would like to see, if this get approved, they already know about the violations, the code enforcement issues, and with those conditions, you know, I personally would like to see code enforcement 100% taking a look at this site, so they comply with all the county laws. Sometimes, you know, people and I encounter on a daily basis, mostly business or people, the regular community doesn't understand all these rules. But once they know, they cannot say they didn't know about this. So that's, you know, kind of balancing, but also educating our community that from now on, they have to comply with all the rules.
I'm now just reminded of enforcement. It made me think of a condition that's listed here on page 5 for post-approval monitoring annual report. It just has 2 years of reports. Again, I would think that we would want to have more years of reports listed because, as has been mentioned, a well-run church will grow. So I think we want to do that, and I don't know if, again, if it's approved, if we'd want to even check in earlier after the property opens rather than 13 months, but that's the question. But otherwise, I think we should definitely extend the time period of reports. I know we can always change it in the future if we feel like it, if it seems that everything is being complied with. So.
Well, so how it's worded right now, typically we do 13 months after final inspection because that's, you move in, you use a year, you see how it's gone. I guess staff would advise, it does have language for 2 years. At that time, if you think it's warranted for additional time, you can extend it at a time. You're well within your bounds to ask for more monitoring now, but you do have that right to ask for more years after the initial 2 years. You could consider in this case, just given the violations, if you want a status report in 6 months, just after issuance of the use permit, as a check-in, that's up to you. Again, the presumption here is they won't be up and operating until the permits are issued and they've moved in, given the history. If you'd like, you could ask for a report back just in 6 months to see, are there activities, is there something to report back regarding zoning violations? Are they on the path to obtaining their permits and complying with the use permit? So that could be considered.
Thank you. I think a 6-month status report, and I would personally go for like 5 years of the monitoring reports, and we can always, again, reduce it if necessary. I think I would plan for more given the history of the property.
May I ask a question of Commissioner Schmidt? Are you just talking about the annual report or also the noise monitoring? I have a concern with requiring the applicant to pay for 5 years of noise monitoring if in the first 2 years it's not an issue. But an annual report, I think, can focus on particular issues rather than require hiring a consultant that may not, hopefully won't be necessary after 2 years. So we'd be modifying condition 27, not condition 28. Is that right?
Yes, that's excellent.
While you're looking at that, I would support that.
Okay. Any other comments from anyone? I'd like to make a few comments. This is sort of, it's an unfortunate place to have all of us in where we are looking at a use that in the past has not really followed the rules and has been told time and time again to do that. And eventually they are doing it, but it's taken quite a bit of effort on the part of the county to get to that point. But do I, as a commissioner, base my decision on what has happened and what is happening right now? We have a staff that indicates that there are, this use is acceptable in the area, that it, with conditions, it can come about. The staff and the county will put itself in the place, really, of monitoring and enforcing those conditions. I think that's going to be, they're going to be called upon quite a bit to make sure that that's going to happen. That's going to be part of it, mainly because of the past behavior of the applicant. I cannot vote against something that does fit into the county, can be conditioned within the county, as recommended by staff, and that the background, the past, even though bad, has actually improved. I think that's been very clear. I am skeptical, but I'm certainly willing to go forward and support this with the conditions changed, as my fellow commissioners have indicated.
I just have a question for staff that I don't remember if we've asked that specifically, but if this is approved, if it is built, if the applicant violates conditions and continues to do so, can the use permit be revoked? So that, in essence, can it be closed down if the applicant continues to violate the
Yes.
conditions? The answer is yes, it can be revoked. Thank you.
Commissioners?
Does that then mean it basically would be allowed to continue as a residence, but no longer as a assembly?
Well, they'd have to obtain the right permits and install it as a residence. I mean, it's a separate use from the use permit for assembly, and just the residence would be treated on its own terms.
Okay. Can we have a motion?
I can if you don't want to.
We can maybe fashion one together here. I just would say, too, that I think all of us are skeptical because of the past performance, but it seems like this is something that can go forward if the applicant does follow the conditions and follow them very exactly, because we know we will find out if they're not followed. So I will move the recommended actions. That's adopt mitigated negative declaration and mitigation monitoring and reporting program. Approve the use permit, architectural and site approval, and grading approval for the proposed religious institution Canh Temple. But we have some additions. Corrections from staff. Condition 3 to be changed as recommended by staff. requiring the mobile home to be removed within 60 days of final approval. And condition 6, approved hours of operation, change the portion on Sunday to eliminate the 50 attendees at one time portion. And to change the page 5, post-approval monitoring annual report to require monitoring of that report provided for 5 years instead of 2, and to add a status report at 6 months, and to add or to modify condition number 44 regarding the use of chemical toilets for special events exceeding 100 persons. Chemical toilets shall be required to augment the restroom facilities. And I can't recall if there were other conditions that we wanted to change.
Let me just clarify on the 6 months, that's from the 6 months of today or 6 months from the final occupancy?
From the final occupancy for status report. Yes.
Just to clarify,
Yeah.
we have one 13 months after final occupancy.
Okay. Well, you suggested a 6-month status report. Did you mean from?
If the concept was, if the commission wanted, it was 6 months after final issuance of the use permit, there would be a check-in on the status.
Oh, okay, after the use
That
permit.
was my understanding.
Okay.
Yeah.
And
Okay,
it might not be today if it were appealed to the board. It
Okay.
might be a later date that starts the 6 months running.
Okay,
But-
yes, let me change that then to 6-month status report after final approval of the use permit. Thank you.
Second.
It's been moved and seconded to adopt a mitigated negative declaration and mitigation monitoring and reporting program, and approve the use permit, architectural and site approval, and grading approval for the proposed religious institution with the modifications as stated in condition 3, condition 6. On page 5 of the conditions, requiring a 5-year monitoring period and a status report at the 6 months after the final approval, and condition 44 as stated. Any questions, comments? Everything clear for staff? All those in favor say aye. Aye. Opposed? 5-0. Thank you.
Anyone dissatisfied with the decision of the Planning Commission may file an appeal to the Board of Supervisors. An appeal must be filed within 15 calendar days after the date the Commission makes its decision. All appeals must be submitted to the Planning Office accompanied by a non-refundable filing fee.